tomorrow, on March 22nd, the United States Supreme Court will hear arguments in the trademark case, the Jack Daniels dog toy case. The case is officially called Jack Daniels Properties v. VIP Products LLC. If it looks like I'm excited the Supreme Court is hearing a trademark case, it's because I am. In a nutshell, VIP Products created a dog toy that was made to look like the famous Jack Daniels trade dress. Jack Daniels is a whiskey company that has a distinctive bottle and labeling. They have several registered trademarks. They have a registered trademark for the bottle itself. There are also some specific elements to the label here. You have Old Number 7. You also have Tennessee Sour Mash Whiskey with the word Tennessee in a script font. There's filigree around the border of the label itself. VIP Products makes dog toys, and they created this rubber squeaky toy to essentially parody the Jack Daniels bottle. You can see that it is shaped and designed to mimic the Jack Daniels bottle and label. It's called Bad Spaniels and says, "The old number 2 on your Tennessee carpet." This is clearly a joke and meant to be humorous. It's also 43% poo by volume and 100% smelly. Jack Daniels, though, is not amused. It claims to, quote, love dogs and, quote, appreciates a good joke, but it, quote, likes its customers even more and doesn't want them confused or associating its fine whiskey with dog poop, end quote. The issue here is, does a product that copies a registered trademark in a humorous way receive a higher level of First Amendment protections for speech or artistic expression, or should there just be a normal likelihood of confusion analysis? The Supreme Court will also consider whether selling a humorous mark that copies someone else's mark would be subject to dilution and tarnishment claims. In this case, it's pretty obvious that the dog toy is not made by Jack Daniels, but dilution means that the owner of a trademark can be harmed even if there is no confusion. Jack Daniels is arguing that associating the famous mark with poop dilutes the mark. Tarnishment means that a famous mark's reputation is harmed because of the similarities between a mark and the famous mark. Some famous brands such as Nike, Levi Strauss & Company, and Campbell's Soup Company filed what's known as amicus briefs with the Supreme Court. An amicus brief is a brief filed by a non-party who may have an interest in the outcome of the case. It's not surprising that these brands would support Jack Daniels. The brief that surprised me came from the United States government. The Solicitor General doesn't often file a brief without a request from the court, but the government thought this issue was important enough to file a brief supporting Jack Daniels. I may be biased because I'm a dog lover and I don't drink whiskey. I'm also a huge fan of the BarkBox Company and their fictitious trademarks. I wonder if a ruling in favor of Jack Daniels would mean an end to the really humorous dog toys that I've come to love. And Barry's come to love too. But does Jack Daniels have a point that poop jokes go too far? Would a ruling in favor of VIP Products open the floodgates to inappropriate parodies and crude humor? I don't have the answers to these questions, but the Supreme Court should soon. I look forward to hearing your thoughts in the comments below. Trademarks are supremely fun.